Yeah, welcome everyone. Yeah, thank you so much for joining us. Pretty much the reason why I decided to host this is that I had a couple of clients and friends not have a living trust, and there was a lot of confusion and a lot of heartache involved with them not having everything in place. Let me introduce you to Kevin. Kevin is he's my title guy. Let me share screen here. Yeah, there we go. Can you guys see the share or not yet?
Yes.
All right, yeah. So Kevin is he does title. He obtained his bachelor's of science degree from University of Laverne, magna cum laude, which is what I had the last 3 years. He has an MBA of University of Redlands. He started in real estate, working in banking in '93. He worked for some of the nation's largest savings institutions. He received extensive training in lending, sales, appraisals, back office, banking, escrow, and title, and of course, probate and retail and commercial banking. He has extensive experience in the title industry since '99. He's a probate specialist. He reviews files daily, and that involve deceased parties, probates, trusts, estates, court orders, etc. He has a never say die attitude, which is what closes deals. That's why he's my guy. It's estimated he's closed over 15,000 of these transactions while working as a title rep. He uses his experience to be able to close the toughest transactions. He has two books, Probate Real Estate Sales 101, Amazon bestseller, and his second book is Wholesaler's Guide to Closing Real Estate Deals. Currently, he helps attorneys, real estate agents, and investors close their transactions. He's the VP of at Lawyers Title, and stop share, and then highlight. Let me admit, and then highlight Kevin here. Spotlight. Here you go. So Kevin, I have a question, two questions for you. What's
Sure.
the number one mistake that people make when funding their trust?
Number one mistake, clear cut, that people make when funding their trust is not having a professional create the deed. Funding the trust means you deed the property to the trustees of the trust. And the number one mistake people make is they do the deed on their own, or they pay someone that isn't a professional, doesn't really know how to do it. And so I've even seen one situation where the people paid an attorney to do their trust. The attorney gave them a deed for their property, but they also had a different property. I don't know if they didn't tell the attorney about that property, or for whatever reason, the attorney didn't create the deed for that property. And of course, they did it themselves. They did it wrong, and there were problems because of that. So, number one mistake for sure is not having a professional, meaning either an escrow officer that does that type of thing for a living, or a document company that gets paid to do documents, or an attorney, a law firm, someone like that, not paying a professional to do the deed to their trust.
Yeah, what other common mistake do you see on title when dealing with trusts or heirs?
There's quite a few, and that's really what my presentation is about. Another thing that's common is what I call the poor man's will. It's where, grandma says, I'm getting older, so let me put my son on title so that when I die, the property doesn't go to probate. There's no problem. They can handle everything. It sounds like it's a great thing to do. It sounds like it's easy. You bypass everything and you're good to go. The problem is there's some big issues with that. Number one, grandma loses control. Grandma no longer has 100% control of the property. And I've seen situations where a parent added a child, and then later the parent wanted to do something and the child didn't agree, and the parent couldn't do what they wanted to refi. The parent was not allowed to refi because the child didn't agree with the transaction. So it causes problems there. Sometimes the kids have liens or issues attached to their name. Those things attach to the property when you put the child on title. So, or the adult child I'm speaking of, those liens attached to the property. It can cause a future reassessment in the future when mom or grandma passes away. But the biggest thing, the biggest problem is there's no stepped up basis. And what does that mean? When you buy, if you buy something for $1 and then later sell it for $2, the government says, okay, your cost basis for the product was $1, you sold it for 2, so you have $1 of profit. Okay, and it's the same thing with houses. If mom bought the property back in the 70s for $55,000, and now mom's doing their estate planning, if someone is added to title with mom, then they take on her cost basis of 55,000. So if mom passes away and then later they sell the property, anything, whatever they sell it for above 55,000 is their profit. Of course, they take out whatever repairs you did on the property and that sort of thing. But that's a huge potential tax liability that's waiting to happen. Whereas if you inherit a property, meaning either they create a trust and I get the property from the trust, or they die and I get the property from the probate case and I inherit the property, then I get a step up in basis. I receive the property at the date of death value. So mom bought it back in the 70s for 55,000. Mom dies today. I get the property based on today's value. So if I sell it today or even a couple years from now, there's little or no profit when I sell it. And so it wipes out that tax basis.
Nice. Thank you, Kevin. Kevin's going to receive an award tonight, so he'll be logging off. Congrats. Yeah, thank you for joining us. I'm going to hand this over to Keith. Thanks, Kev. I appreciate
Thanks for having me.
I'm going to read Keith's
Congratulations, Kevin.
Thanks, Keith. Appreciate it.
I'm going to read Keith's bio and then we'll get started on Keith's questions. Here we go. Oops. Here we go. Up share. Here we go. Here we go. All right. So Keith Moten, he's can you all see the print? Yeah. Okay, Keith Moten is an attorney specializing in estate planning, probate, trust administration, trust litigation, and all things wills and trusts. And he's the founder of Moten and Associates. For 20 years, Keith has assisted families putting together their estate plans, setting up business successions, and litigated estate issues. Due to his experience as an estate litigator and estate planner, he has a unique perspective of being able to advise and help his estate planning clients avoid potential litigation issues. Keith was named Southern California Rising Star Attorney in 2017. He was named as Southern California Super Lawyer from 2018 to 2024, and he has conducted numerous lectures and speaking engagements to attorneys and general public on estate planning and estate litigation. So let me introduce you to Keith Moten. I'm going to highlight him. And here we go. Keith, what is the number one mistake you see when people are funding their trust?
Well, first of all, thanks, Mark. Thanks for the intro, for the very kind intro. Thanks for having me. Thank you guys for your time and having me on here. I think the number one mistake that people make in terms of funding their trust is actually not funding it. I think a lot of times, the thing about estate planning is that it looks very easy on the surface because on some level it's forms. The issue, and so because of that, a lot of people feel like they can do estate planning. And so they go to paralegals, they go to attorneys who don't really do estate planning. And then you have a trust that looks good, but they actually don't fund them. So they'll do the trust, but they won't do the proper documents to fund, notably their real estate into the trust. And then sometimes they'll fund the real estate into the trust, but they won't fund their cash accounts into the trust. So those are probably the two most common mistakes in funding people's trusts.
Yeah, what is the difference between a living trust and a will, Keith?
Sure. So will, first of all, the most important distinction, a lot of people don't know this, but when you have a will, if you pass away with just a will, your estate still has to be probated. A lot of people don't know that. So if you just have a will and not a trust, you still have to do probate. However, a trust will completely avoid probate. So that's the key difference. The other difference is just physically speaking, a will is like 2 to 3 pages. So it's like, you know, one or two, three, not one, but maybe 2, 3 pages. A trust is like a little book. You know, it's like 20, 30 pages. And it's because it covers so many different contingencies. It says it goes to this person. If this person passed away, it goes to that person. We're going to name this person as a trustee. If that person isn't around, then we're going to name this other person. Wills are usually much more straightforward. It's just if I pass away, I name this person, I give this everything to this person, and that's kind of it. So, but the key distinguishing factor is the fact that a will still has to go through probate, whereas a trust doesn't.
Right. What are the advantages of a living trust in California, Keith?
So first one is definitely avoiding probate. But I think the other advantages are with the will, and I'm not sure this may be something that we cover later or not, but with the will, everything happens like I pass away, I give it to these people. But with the trust, and everything happens at death, basically. With the trust, you can stagger out distributions. So you can say, like if you have minor children, you can say, I give it to my kids once they reach the age of 25 or once they reach the age of 30, or I can stagger it so that they get a certain percentage at 25, certain percentage at 40, and the remainder at 45, or however you want to do it. And I think just in general, in addition to the probate avoidance, you have much more control in a trust than you do over will because a trust can be administered for a number of years. You know, you've heard of the term trust babies. Well, that's because, or trust fund babies, that's because a trust is giving someone ongoing money over a course of years, whereas you will never hear of a will doing that. The way that a will is designed, you pass away, you go through probate closes, it gives the beneficiaries of the will the money, and that's it. Whereas a trust can be kind of like a continuing enterprise in some ways.
Right. The next question I have is what are the common mistakes people make when setting up a trust? I think you already answered that, right? Yeah. So, how do I fund a trust with my assets?
So, all right, so first of all, I would say, again, to me, this is where the litigation side comes in. I can answer that first question. Most common mistake is either going to a paralegal or going to an attorney that doesn't do estate planning. And the reason why I say that, in addition to the other stuff I said, is as a litigator, you know, I can't control who comes into my office, and I don't know what role they play. So they may be the proverbial good guy, or they may be the bad guy. I have no way of knowing, you know, before I retain them. But I can say that whenever I see a paralegal drawn up trust, and I can tell when an attorney that doesn't do estate planning does a trust. As a litigator, I personally love to see those, right? Because usually I can kind of wiggle my way in because there's always going to be something wrong with those. And you have to understand whenever I do a trust for somebody, the idea is that someone else can pick up the ball and run with it, right? Someone else can read it and say, oh, I know exactly what dad meant or mom meant or my uncle meant or whoever, right? The problem is when you go to somebody that's not as adept at doing that, sometimes they may misinterpret things or they may do things in a way that looks like it's okay to the naked eye, but to an attorney, it's like we get paid to argue different interpretations of documents, right? So if they leave a critical clause open for interpretation, we have a field day with that stuff as litigators, right? If it says, I give it to A and then to B, right? And you meant to say A or B, we could spend 2 years in court litigating what and or means, or then or. Like And these are the types of mistakes that like wind up like costing you. So that's the number one mistake. But in terms of funding, usually you have to do a deed, transfer the trust into the property, and then for cash, each financial institution or cash accounts, because it could be a stock or bond account, you can transfer mutual funds into trust. You can do a payable on, you can list the trust as a beneficiary, or you can do a name change, changing that account into the name of the trust. So there's numerous ways that you can do it, but those steps have to be taken because I've had cases before where people come to me and say, we want to administer this trust, and there's nothing funded into the trust, and I'll tell them like the trust doesn't own anything, and therefore we have to do a probate, which is like defeats the purpose.
Yeah, and you can't just try to take money out of the bank account. It's either there or it's not, right?
Yeah, yeah.
Yeah. What happens if I forget to move an asset into the trust?
Well, so again, it all depends on how well the trust is drafted. Like well-drafted trusts will have like a backup provision that says in the event that this asset is left outside of the trust, you know, this provision of the trust serves to transfer it back into the trust. Um, and that's basically if assets are left over as you pass away. While you're still alive, that's one of the reasons that we encourage clients and people to review their trust and have an attorney review their trust, because while you're still alive, you can still draft up the deeds, transfer the property to the trust. You can still change the names of your accounts. So there's multiple fail safes if you don't transfer your assets into the trust while you're alive. But a good estate plan has a mechanism to transfer assets into your trust even after you've passed away.
Yeah, because boilerplate trusts wouldn't factor in if you bought a new house,
Right.
and then yeah, versus someone like you would make sure that's handled ahead of time. Who should I name Keith as a trustee or a successor trustee on these trusts?
So usually the way the trust works is that you're always going to be the initial trustee of your trust because you still want to retain the power to control all of your assets. Like you don't lose control of your assets by virtue of creating a trust. So you are the initial trustee, but as to the successor trustee, who's the person that takes over if you pass away or if you become incapacitated, there's no hard and fast rule. But my best advice would be you have to ask yourself the question of who can I trust to take care of things for me and my family if I'm not here? Now, if you're married, then hopefully that's your wife or husband, hopefully. Um, but if not, then who is that person? And that's really like an answer that you reach only after you've kind of reflected on it. Sometimes the answer jumps out at you. And the other thing is, who's going to do the right thing when nobody's looking? And that's important because when we're gone, like there's nobody to look over that person's shoulder, right? And this person is going to be in charge of your life savings. They're going to be in charge of your real property, and it's not always necessarily, your brother or your best friend or your sister or the person that you have a good time with, right? That person that you have a good time with may be the person that says, 200,000 sitting in this account. Nobody's going to miss another 10 grand or 20 grand, So it's like, who is the person that I can trust when nobody's watching to do the right thing and also to get professional help? Um, and that's a completely subjective answer for all of us.
Right. I think if you don't name your spouse, you might have to be on the divorce webinar.
Yeah, yeah.
So
Yeah.
Keith, can I name multiple beneficiaries or staggered distributions?
Yes. So You definitely can have staggered distributions, and you can also name multiple beneficiaries. As a matter of fact, one practice that I like to engage in is what's called contingent beneficiaries. So that says, in other words, or for example, I'm giving everything to my daughter, but if she doesn't survive me for some reason, then I give everything to my niece. So that's one way of multiple beneficiaries. Those are contingent beneficiaries. Or you can say I'm splitting my trust. I'm giving it to 1/3 to son A, 1/3 to daughter B, and 1/3 to daughter C. So this, at the end of the day, I always tell people that whenever you do a trust or an estate plan, you're the author. I'm just the scribe, right? I'm here to advise you on that's may not be a good idea depending on circumstances, but I'm mostly here to write down your wishes. And that's the whole purpose of it. The whole purpose of doing the entire purpose of doing a trust, honestly, is to write down or have memorialized your wishes while you're well and doing okay. So many of my lawsuits that I've done, at this point, I've done probably 1,000 lawsuits, are when people are literally on their deathbeds, suffering from some kind of ailment, and they're 2 or 3 days before they pass away, they do a trust. And because somebody doesn't like it, they come in and say, oh, they weren't in their right mind. So now I'm going to try to overturn everything that they did. But when people come to me and they say, my dad did this trust or my mom did this trust, or when they do it, like 10 years ago, and I want to overturn it, I'm like, I'm not taking the case because chances are they're of sound mind and sound body when they did it. So the whole purpose of all the stuff is to do this trust while you still have all, relatively young, or even if you're not, but while you have all your faculties and so that your wishes can be carried out exactly the way that you want to be carried out. I don't know if
Well,
that
not
answers your
just
question. I kind of went
yeah,
off on
yeah,
tangent, so
yeah. Well, not just that. You don't know when your number is called, right?
yeah,
I
yeah,
have a friend. He was fit and he worked out. He had a 4 pack. He's 56. Had a heart attack.
yeah, yeah,
And he wanted it to go to his longtime girlfriend. And this is actually what motivated me to do this webinar. And he was going to do it. He was going to call you, and boom, 56, 4 pack. Fit guy dies of a
yeah,
heart attack. And it went to his brother, who he hates. He
yeah,
literally hates his
yeah,
brother.
yeah,
And so the brother's the executor and the only heir, most likely. And the guy won't even pay for a memorial. He's going to do the cheapest funeral for a
yeah,
$1 million estate, and the girlfriend is out of luck.
yeah.
Uh, well, anyways, yeah. So
Well, I
question:
mean, just to add to that point, if I
Yeah,
could, because I think
yeah.
what you said is extremely important.
Oh,
You
and you
know,
know this case that was the case where they were
oh
asking
yeah,
you.
we talked to
Yeah,
him.
yeah,
Yeah,
yeah.
yeah.
Uh-huh.
So, a couple things. Number one is I'm not here to be morbid. God
Yeah.
willing, everybody on this call it's going to
Yes.
be here for another 50,
Yes.
60 years, and so hopefully we're not, but I always tell people whenever you turn on Channel 4 or Channel 9 or KCAL or CBS and you hear about a fatality on the freeway on the 710 or the 10, the 405, that person didn't wake up and say, this is it. Nobody ever, my mom passed away when I was 25. She had a terminal illness. She died in July. I saw her notebook that said August, you know? So nobody ever, even terminally ill people, a lot of times won't say, I'm planning to check out. I don't think it works that way, So it's really more so like doing things again while we can and not thinking like I'm going to pass away tomorrow. But it's like, okay, but if it happens, this is what I want to happen. Number one. And then number two, you brought up a great point because, and I'll close what I'm saying here with this. There's already an estate plan for you in place. It's just whether you want the one that's made for you already, or the one that you want to do. That estate plan that's made for you is called intestacy, and it's set by law. If you pass away, if you have no spouse, then it goes to your kids. If you have no kids and no spouse, it goes to your parents. If you have no parents, kids, or spouse, it goes to your siblings. And it keeps going, right? So it's like, and if you have someone that you're not married to, or a kid that you claim is not your biological kid, like they get left out in the cold, just like Mark was talking about. Like it happens. So I think the biggest thing with all this stuff is like it's not so much about, oh, I'm going to do this and because I'm going to die. It's like no, like but whenever it happens, or in the event that it happens, like you guys are covered. It's really the thought process of it from my standpoint.
Yeah, if I'm ever on my way out, I'll have peace knowing it's done. No
Yeah,
headache. Yeah. Question. How often do you think I should review my trust?
I think you should review it at least annually, because a lot of times all that trusts are a snapshot of how things are today. And I think that's all you can do, right? You can't, like, let's say if you have a 18-year-old kid, for example, like today they may be irresponsible. So you may say, oh, I want to do this or do that, or your relationship isn't that great with somebody right now. But things can change, right? Next year, you can look up and it's like, no, man, my 18-year-old's really getting her life together, and so I want to give the business to her. I want to, so it's like, but if you don't review it annually, you tend to forget these things, and then let's say something happens 20 years from now, and you still have this old estate plan that says me and my 18-year-old aren't on good terms, and I'm only giving them $5,000. So it makes sense because it's revocable, meaning that you can change it at any time to at least take a look at it. And you can take a look at it and say, no, still the same way. I don't want to change anything. And that's fine. But again, if you're looking at it every year, things are bound to change. And the whole purpose of a revocable trust is for you to have the ability to continue to make change because life changes.
So if I can make changes, could I change the beneficiaries or the trustees?
You can change everything. You can completely revoke it. You can say, I'm not giving anybody anything. I'm giving everything to, Salvation Army, or I'm giving it to my church or whatever. Like there's been many cases where people decide I'm not giving anything to anybody. And not to say that that's something that I would advise, but you can make as many changes as you like, as long as you're alive, and then as long as you're of sound mind. And even then, to be honest with you, even if you have Alzheimer's or dementia or stroke, capacity is still presumed. So you still retain the ability to make as many changes as often to your trust as you like.
Uh, yes, someone. So do I need an attorney to create a living trust in California?
I would advise getting an attorney to do it. And I'm not just saying that because of me. Like I said, my experience is that um, this is what I always tell people when it comes to practicing law. You can give yourself a tracheotomy, hypothetically, right? Doesn't mean you want to do it. You can go out there and download one of those forms or go to one of these websites and try to do it yourself. But it's like just like with a medical procedure, if you make one cut, a centimeter too deep or too far to the right or too far to the left, like you can cause irreparable damage. And it's the same way with trust, right? You may not see it with the naked eye, but like if you do something wrong, then the whole deck of cards comes falling down. So yes, I definitely uh, advise whenever you do a trust to see an attorney. And the other thing is, um, I'll say this also. I've done probates and I've done trust, right? And this would go to a point that we discussed earlier. A trust is going to cost you a couple $1,000s. Average statutory fees on a probate, $20,000. So yeah, you may escape that cost now, but like your kids or spouse or whoever is going to pay way more money later on. So it's like it just makes sense to kind of get it out of the way, take care of it now for a fraction of the cost that it's going to cost you later.
Yeah, I do a lot of probate real estate deals, and that those things are tied up 12 to 18 months.
Yeah,
Also,
yeah,
your family's on hold, and a lot of these people really need the money right away,
yeah.
and they're stuck. Question: what other documents you think should be created along with the trust, like power of
Yeah,
attorney or
yeah.
healthcare?
So there's
Yeah.
so typically what we do is we do an estate planning packet, because a trust. So I'll explain the different documents. A will only takes effect after you die. A power of attorney only lasts until you die. A trust covers while you're alive and after you pass away, but there's all these other things that come in, like healthcare power of attorney, giving informed consent to medical procedures when you can. A HIPAA authorization is allowing someone else to view your medical records, in the event that they have to make a medical decision on your behalf. A power of attorney. A power of attorney covers non-trust assets, whereas opposed to your trust only covers assets that are funded into the trust. So you really need all of those documents working together: power of attorney, healthcare power of attorney, HIPAA authorization, in order to kind of give a comprehensive estate plan that covers all kinds of different contingencies, because we're really trying to look into a crystal ball and nobody knows what's going to happen in the future. So we try to do as many documents as we can. But those 4 or 5 documents, including the trust, usually will cover pretty much all the contingencies that could potentially happen.
Yeah, I take a lot of comfort in knowing that, like, I have a healthcare directive.
Yeah.
Because I mean, yeah, you do need someone making decisions. Like, yes, give them the procedure, don't give them the procedure. But God forbid, like, I'm on machines,
Yeah.
and my personal choice is, leave me on. If I have a shot at getting out, then leave me on. For however long is realistic.
Yeah.
But then once it's not realistic, take me off.
Yeah.
I think if I left it, just with no medical directive, there would be someone I love trying to make that choice for me, even if they knew it's what I wanted. I think there'd be like a huge amount of guilt for that person to ever pull the plug for me and choose the end of life option.
I've seen it. I've seen it happen before. Someone that this is a while ago, but my ex-girlfriend way back when, her mom was in a coma, and half the family was split. Half the family wanted to keep her on, and she had no advanced healthcare directive, so it was totally silent. Half the family was like, "We don't want her to suffer. We think we should just pull the plug now." And half the family was like, "I don't want to be responsible for pulling the plug. And when my mom maybe has a chance to survive." And there's been numerous like litigated cases over this, like where it gets so bad to the point where, families go to court over the right to. And another thing is like if nobody's the healthcare power of attorney, then nobody has the right to make that call anyway. You know, so I think the whole thing about all this stuff is like once you have people to think about in your life, um, people that you provide for, people that you care for, like you want to make it as easy on them as possible, you know? And even though I will say like it's not an easy thing to do, it's not easy to think about like not being here anymore and what happens after I'm gone. Like it's a very unpleasant thought. But at the same time, like you also don't want your kids or wives or husbands or whoever, nephews, nieces, whoever it is, parents, to like go through the grief of dealing with your loss and then all of these legal problems, like I can't access the money, I can't, pay the mortgage. I can't, like, so it's like you just want to facilitate that for somebody to step up and take care of that in the event that you can. Whenever that is, God willing, again, we're talking about decades into the future, but one way or another, it's just like you just want to bite the bullet on the unpleasantness of dealing with that in the short term to avoid a whole lot of unpleasantness for somebody else to have to jump through the hoops dealing with that in the future.
Yeah, do you have any closing thoughts, or do you want to open this up to Q&A?
I think that's pretty much where I want to leave it as far as closing thoughts. But yeah, so we can open up to Q&A now.
Yeah, anyone that you can either raise your hand or write in the chat, um, or unmute yourself and start talking if you like. Let me see, does anyone? Oh, okay. So Jess is that's Jesus Mesa.
Yeah, it's me, Jesus. Sorry.
Yeah. Go
Sorry,
for it, Jesus.
I jumped in a little bit late into the meeting. So can you just state back the difference between a living trust and a will?
Sure. Yeah, the biggest distinguishing factor between living trust and will is that living trust avoid probate and wills don't. If you have a will, you have to go through probate. If you have a trust, you do not. The other thing is trusts tend to be much more comprehensive and also can be effective during the life of the person that created the trust and after, whereas a will is only effective after the person passes away.
Yeah, plus with the will, just the basis for the property or the profit, is it affected if you transfer a property with I don't think you can transfer a property with a will, can you?
You can, but only after probate. So with the will, the order, what happens is at the conclusion, so you have to do a probate with the will. At the conclusion of the probate, the court order will serve as basically a deed, transferring it from the person who passed away to the beneficiaries of the will or the heirs of the estate. It's terms of art, but kind of the same thing. And you do still get the step up in basis, but you also have to keep in mind that you get the step up in basis, and I want to go too far down this. I think Kevin might have spoken about this some, but you will get reassessed if the child, and first of all, it's only husband and wife or child, but assuming that it's a parent that passes away that gives the property to their child, you do get to step up in basis, but you get reassessed if you don't reside at the property or use the property as your primary residence.
Right. Okay. Do we have anyone else with questions? Yeah.
Hey, Mark, no questions from us, just if you, after the fact, if you could forward us contact informations of the gentleman that spoke so we could
Yeah.
kind of look into moving forward on some of that stuff.
Sure. All right. Yeah, I know Jesus wanted information too. All right. Yeah, I'll text you all Keith's information and his email, and then we can go from there. Yeah, I appreciate your time, Keith. I know you're busy, and to take an hour out of your time for us, I really appreciate it. And
Not a problem at all. I mean, thank you guys for having me. I will say this in closing. I got into this because, again, I lost my parents when I was 25. And so I do believe that sometimes, we ask like why things happen to us. And sometimes things happen to us to maybe make the path for somebody else easier. So whenever I can help somebody do that or talk to folks about it, I kind of feel like in a lot of ways, this is what I was put here to do. So happy to speak on it and happy to answer any questions for folks. And yeah, thank you guys for your time.
I appreciate you all. Thank you for joining us. I'll send you guys the recording, and then also send you Keith's information. I appreciate you guys, and I'm thankful that you guys think of your people. And Keith, thank you for being here. And he's